you guys heard about this federal judge who expanded on the transgender restroom prohibition from the Obama administration, saying it didn't just apply here to Texas. It applies everywhere. I want to talk about this because I'm not a lawyer, never pretended to be one, never played one on TV either, but somebody who is Byron Henry, appellate law expert with the law firm Scheef Stone, L.L.P. right here in North Texas. Byron, welcome to the Chris Salcedo Show, sir.
Great to be with you, Chris.
So explain to me why this judge was able to do what he did, and explain to me in detail. I haven't heard much liberal opposition to what he has done.
Well, there was some opposition, of course, to the initial injunction that enjoined the enforcement of the, quote, the directive from the Department of Education with respect to locker rooms and bathrooms and transgender individuals. This clarification order that came down was the government asking Judge O'Connor whether or not this only applied in the 13 states that actually brought the suit, or did it apply nationwide? And the result of that hearing was Judge O'Connor, among other things, ruled that the injunction applied nationwide, thus prohibiting the Department of Education through its attorneys in the Justice Department from enforcing this directive on unwilling school districts or towns until further order of the court. So it is a nationwide injunction that applies to the federal government until Judge O'Connor or a higher court rules otherwise.
Where is Judge O'Connor seated?
Fort Worth.
Yeah, on which court?
The Northern District of Texas District Court. He's a George W. Bush appointee to that court.
Right. Well, how now? And this is probably a lot of folks have this question because, well, I do. How is he able to, being in a district court, say that this ruling applies nationwide?
Well, first of all, he noted in his order other cases in which district judges were allowed or were authorized to issue injunctions that affect the federal government. Mainly it's because the federal government is the party, and the federal government enforces Title IX and Title VII nationwide, and that enforcement needs to be consistent throughout the country. So, for instance, it was just a case between individual parties, for instance, or just against the city council and an individual or whatnot, the injunction wouldn't apply nationwide. But this is the Federal Department of Education and the Department of Justice on the other side of the case. So when you tell the Federal Department of Education you can't enforce a change in the law without going through the legal process by rule, as they tried to do here, then that in effect keeps them from doing that anywhere, because you're telling a federal agency they can't enforce their interpretation of the law. So it de facto keeps them from doing it anywhere because it's against a federal agency or a part of the federal government. So
I get it.
So his citations were pretty strong on that. The real issue is something that was left over from that hearing, and there's going to be further briefing, is whether this order will also apply to Title VII, where the Justice Department also changed the rules with respect to workers, not just schools and bathrooms, but places of employment. And Judge O'Connor is still considering whether or not the injunction would preclude enforcement of this directive on transgender bathrooms to employers, as well as school districts and universities. So we'll have to wait and see on that.
And that would affect places like Target, who have rolled out the welcome mat for those who claim to be of a different sex to use their claimed sex bathrooms. And well, if you look at their stock prices, they've paid a heavy price for that. Byron Henry, appellate law expert with the law firm Scheef Stone, L.L.P., right here in Dallas, Texas. So this is key because, and thank you for clarifying this. It's not because of the judge's position that the reason why this applies nationwide. It's because of who the defendant is. This case is the federal government. And if you're prohibiting the federal government from doing it in Texas, you're in effect preventing the federal government from implementing it nationwide. Now that makes all sense to me. Now, this was all a political this is me. I'm not expecting you to comment on this, Byron, but in my mind, this was all a political show designed to provide the Democrats with something to run on, because Barack Obama has been one of the most sorry excuses for an occupier of the Oval Office this country's ever seen, and they don't have much to point to and say, oh, look at all these successes. His signature health care law is failing. His light footprint leading from behind foreign policy is failing. So the Democrats were desperate for something to run on, and this was it. What do you think will be the future post-election? Do you just see the Democrats going, okay, whatever way it turns out, they're just going to drop this whole thing because they've used the transgender community to for their political effect, and they're just going to drop it? Or do you think they're committed for the long term on this?
I think probably they're committed, and I'll tell you why I think that is President Obama has found, I don't want to call it a loophole because it's not constitutional, but he has been caught with his hand in the cookie jar on a number of occasions, especially by lawsuits from our Attorney General here in the state of Texas, but other states as well, attempting to force major policy initiatives and changes, really changes in law, through administrative rulemaking. And that's something that is not new. It has happened in the past, but President Obama has used these rule changes in immigration. He's basically rewritten a lot of his own Obamacare regulations and changed the rules without going through Congress. Of course, we know about this transgender bathroom initiative, and there have been others that they are attempting to change the law through administrative rule. And case after case, at least recently, judges have agreed with the states and others challenging it that you cannot change the law in this country by administrative rule. You have to go through Congress. And I suspect if there's a Democrat president in the White House after President Obama, they will continually attempt to use the executive branch and administrative agencies to make policy if they can't make policy through passing laws in Congress.
Give me your opinion, since you brought up the presidential election, and many folks concede that one of the big issues in this election will be the future of the Supreme Court. If Hillary Clinton is in the Oval Office and she is able to appoint justices in the tradition of Ginsburg, who has said that she does not support the U.S. Constitution, she supports countries that are forming new governments, not use the U.S. Constitution as their model. This is the type of justice we believe that Hillary Clinton will appoint to the court. What kind of rulings coming out of the high court do you fear the most?
Well, I fear rulings that do not enforce the separation of powers. People can talk about abortion and people can talk about the Second Amendment right to bear arms, but I fear any rulings that do not enforce the separation of powers. I mean, checking the president when the president, whether it's a Republican or Democrat, colors outside the line, checking Congress when they exceed their authority. And I expect that justices in the mold that Secretary Clinton has said she would appoint would not only jeopardize, basically make affirmative action the law of the land, enshrine abortion on demand as policy of the United States and enforce it on all the states, probably scale back, if not completely reverse the Supreme Court's opinions on the right to bear arms, but also give the president the leeway to basically change immigration policy, change bathroom policies, and change all of these worker policies through administrative rule instead of following the Constitution and making sure you have to go through Congress. And that's the biggest threat, I think, to the Constitution and to the Republic, is that the Supreme Court is there to make sure each branch stays within their respective spheres. And I believe that if Hillary Clinton's nominee is placed in the type nominees are placed on the Supreme Court, they will allow presidents to basically run the country through administrative agency and just completely bypass Congress simply because it's difficult to get things done in Congress. And that's not the way the Republic was designed to work.
Did you watch the third debate?
I watched portions of it, yes. Did
you watch the beginning? And this is the specific question. Now, let me just tell you what happened. In the questions that Chris Wallace asked about the Supreme Court, Hillary Clinton gave her 2-minute response and never once mentioned the Constitution of the United States, and I found that to be significant. You?
Certainly. The number one issue, whether it's Donald Trump or Hillary Clinton, my number one issue is that a Supreme Court justice enforces a strict separation of powers and makes sure each branch of government stays within their respective spheres. That way, when it's a state's issue, the states vote on it. If it's a congressional issue, the Congress handles it. When it's an executive issue, the executive handles it through the presidency. And I fear that by both sides asking for, wanting to nominate candidates or put up nominees that simply share their policy choices, you're missing the forest for the trees. I tend to agree with Donald Trump on the type of justice we need, but that's mainly because I believe in a constitutional strict separation of powers like Justice Scalia professed, and that's why I believe that that's the better choice of the two with respect to the Supreme Court.
Gotcha.
But we shouldn't be looking to shouldn't be looking to put nominees up for the Supreme Court that share our policy preferences. We should make sure that they enforce the Constitution and let the democratic process promulgate our policy choices.
That's the way it's supposed to work. Byron Henry, everybody, appellate law expert with the law firm Scheef Stone here in town. Sir, appreciate the time as always here on the Chris Salcedo Show.
My pleasure.